Michael, as the senior partner in Kahn, Gigliotti Associates, what do you feel that our firm brings to the table with respect to college students charged with crimes?
Well, I think we bring something extraordinary to that, and that is that when people are charged with drug offenses, 90% of the time it is because a police officer searched them or their vehicle or sometimes their house or college dorm room to obtain the contraband which they're charging them with. I believe my own experience and observations that the vast majority of attorneys will look for the easiest way out, sometimes using up a kid who is a regular user's one bite at the apple, regardless of whether they can beat the case or not.
When you say one bite at the apple, you're talking about the conditional discharge program?
Right, there's a conditional discharge program that says, hey, if you don't have any previous drug offenses, we'll put you on probation for 12 months. We'll give you 3 urine tests, random urine tests during those 12 months. And if you pass all of them, we'll dismiss this criminal charge against you. Well, that sounds great in a vacuum, but if the client / parent's child is honest, they're often going to say, well, wait a minute, it doesn't work for me. You know, I smoke marijuana frequently. You know, I do other drugs. I don't want to live that lifestyle. I'm not willing to commit to that because I'm only going to get caught with a dirty urine and end up back in court. The difference is that with Kahn, Gigliotti and Associates, if there is any way to fight a case, whether or not you're entitled to a conditional discharge, we will hang in there and fight. Why? Because we understand these situations better than most people. We know how to defend these cases, and we know how to spot issues that other lawyers are not even noticing in order to present as a defense for our clients. It has been my personal experience recently in the last 6 months that I have filed motions to suppress, meaning a motion saying that my client's car was searched illegally in a variety of municipal courts lately. And in each of those instances, without having a trial, without filing an additional written brief, I was able to convince the prosecutor that based upon my understanding of the discovery, meaning the police reports, that there were defects in this case and that my client was entitled to a dismissal. And in all of those instances, that request was granted, and the drug case against my client was dismissed instead of a kid taking a conditional discharge that they were only going to fail.